Thank you, Mr. Chair, and thank you, Ms. Morgan, for coming today. Have you, as an acting board member, I think that's the correct title of SDTC, have you had any meetings since you've been appointed to this position with the Minister of Industry or his office?
No, we have not.
Okay, thank you. I'd like to talk a bit about the review of the projects that's ongoing. It's one of your 3 areas. You mentioned that you're reviewing the projects identified for the Auditor General for eligibility. Has he, to your knowledge, has the Auditor General been back at all at SDTC looking at a broader list of transactions rather than just the 226 she looked at?
No, not to my knowledge.
She hasn't. So the Auditor General's then report stands, which was during the audit period, that she reviewed 226 of 420 transactions approved by the board.
That's correct. And one of her recommendations was that we review individually each of the projects that was undertaken during that audit period, and that is what we have. That is a process that we have started.
You're focused on the 226 transactions that were that were mentioned and discussed in the audit, not the 420 in the audit period.
We are focused on all of the projects that were put in place during the period of the audit. So I believe that the Auditor General took a sample of projects and reviewed them, but we are reviewing all of those projects, all of the projects.
Right. So that, yes. According to the Auditor General's report, that's 420 projects. So you're reviewing them all for eligibility? For
eligibility, yes, as per the recommendation of the Auditor General.
And when you look at the eligibility, besides the, I'm presuming you're talking about eligibility relative to the contribution agreements.
Yes, that's correct.
Are you looking at eligibility relative to conflict of interest?
We're looking at eligibility. We're following the Auditor General's recommendation, which was to review every project for eligibility, and we have hired independent firms to assess. 2 individuals, independent, will assess each project for eligibility, and that's per the Auditor General's recommendation. That's
true, but as a person overseeing the governance of this organization, I would think that you would be more concerned overall, not just with the eligibility, but the overall issues that have been identified in the culture of conflict of interest in the organization, at the board and in management, and most of those management are still there. In the culture of conflict of interest, the 226 projects that the Auditor General audited out of the 420, 82% of them were conflicted. 82% of board member approved transactions were conflicted by board members. To me, that goes to an eligibility issue as well, because there is no way those 9 directors represented 82% of the clean technology community in Canada. So are you explaining to me that the board and the review that's going on with the third party isn't delving into the issue at all of the conflicts of interest that were identified, and whether or not these companies got preferential treatment because of their connection with board members? That's not part of the review?
Mr. Chair, a number of the recommendations of the Auditor General were related to strengthening the conflict of interest provisions of SDTC, and those recommendations have been implemented. The board is overseeing the governance of SDTC, and we're doing that with a much strengthened conflict of interest reporting provisions going forward. In terms of the eligibility reviews, we're following the advice of the Auditor General, which is to review each project for eligibility.
But the whole reason we're here, and the whole reason we have a production of documents motion that got approved by the majority of the House of Commons members of Parliament to be collected, unredacted, is that in that audit period, those 420 transactions approved by board members, that represents $856 million of taxpayer money. The Auditor General only looked at half of that and found $330 million were conflicted, and $59 million was ineligible. That's almost 400 million. Of 800 million was conflicted or spent incorrectly. So it boggles my mind that in trying to clean up the governance that the minister said was his goal with transferring it, getting rid of the board, having a new board, that part of that process is saying, look, folks, these projects have a problem. They are conflicted. These board members, like, the project may be legitimate, but how they got in and how they got funding was clearly preferential treatment over that of other businesses in the clean technology space that didn't get funding. And for that not to be part of the review boggles my mind. So will you commit here that you will mandate to that third party that you have doing it to ensure that conflict of interest, which was a big part of the Auditor General's report, is part of your review?
Mr. Chair, we have independent advice on conflict of interest and provisions of the SDTC. And as we go forward, we will be taking advice on conflict of interest issues as well, particularly as we look at reviews and as we look at restarting funding for projects.
Thank you very much.
Thank you very much, Mr. Chair. Ms. Morgan, this is a yes or no question. I take it from your testimony that with respect to the reassessment process that is underway with respect to each of the projects that had been approved by the previous corrupt board, the scope of the reassessments are to determine whether those projects satisfy the enhanced contribution agreement in order to be eligible for funding, but does not include reviewing conflicts of interest that may have resulted in those projects receiving funding by the previous corrupt board. Is that correct, yes or no?
Mr. Chair, we are reviewing the projects independently to assess their eligibility as recommended by the Auditor General.
No, I asked specifically with respect to conflicts of interest, wrongdoing, and so on, because the Auditor General found 186 conflicts, $330 million that went out the door involving conflicts, including $76 million tax dollars, in which board members actually deliberated and voted on approving funding that went into companies that they had interest in. Is that part of the reassessment process, yes or no?
Mr. Chair, if fraud or wrongdoing is found as part of our review of these projects, the board will take appropriate action.
Well, Ms. Morgan, how is it possible to identify fraud and wrongdoing if that's not part of the reassessment process?
Mr. Chair, there are strength and conflict of interest provisions that have been put in place, and no funding will be restarted without those conflict of interest issues also being taken into account. So we're looking at the eligibility reviews by independent assessors, and we're looking at all of the issues before we restart. And should we find any evidence of fraud or wrongdoing, of course the board will take appropriate action.
Why is that not part of the reassessment process?
Mr. Chair, the reassessment process that we're talking about vis-a-vis eligibility is what was recommended by the Auditor General, and we've put that in place with independent reviewers, 2 independent reviewers per project, to assess eligibility.
Okay,
that was the recommendation that the Auditor General made.
It's very clear, or it seems to be clear, that a priority is to get funding out the door, but much less of a priority is rooting out the corruption and conflicts involving hundreds of millions of taxpayer dollars. Now, Ms. Doyle stated, if we find any evidence of wrongdoing on the part of a recipient, the board will take action on recovery. What action has been taken to date to recover monies that improperly went out the door where there was wrongdoing? Because we already know of instances where that has been clearly established. What steps have been taken?
Mr. Chair, the process of reviewing the projects for eligibility is really at the beginning stage, and we've started to review those projects. We are looking at a process to restart funding that will address issues of eligibility and conflict of interest for previously approved projects. And we will only restart funding, Mr. Chair, in cases where these projects have been approved for eligibility independently, and the board has had a very close look at them, as the Auditor General has recommended.
Well, I asked Ms. Doyle, and I didn't receive a satisfactory answer, that in the case of Annette Verscheren, the former chair of the board, $220,000 went improperly out the door, funneled into her own company. This was identified in the Auditor General's report, and Ms. Verscheren has been found guilty by the Ethics Commissioner of violating the Conflict of Interest Act in respect of those payments. It's been months since Ms. Verscheren has been found guilty. What is the interim board doing to recover those funds? What is the interim board waiting for in that clear black and white case of corruption and conflict?
Mr. Chair, it's very important that we follow a clear and transparent process, and that is what the board has put in place. We will have independent reviews, 2 independent reviews for process, per project. We'll assess each project for eligibility.
For eligibility, but not conflicts and corruption.
We're conducting these reviews as per the Auditor General's report.
Thank you.
Thank you, Chair, and welcome, Ms. Morgan, to committee. I'm going to start by following up on some loose ends based on other members' questions to you. Now, I was rather shocked in your response to one of the questions about the law firms that SDTC and the board are retaining. You said a number of law firms, and you also included Osler's in that mix. Now, Edward Vandenberg, I don't know if he is a partner of Osler's or an associate of Osler's, has acquired a notorious reputation for giving completely improper governance legal advice to the former chair of the SDTC board, Ms. Verscheren. She relied upon that advice, as did other board members, to enrich herself and other companies that she was associated with and other board members. Why on earth would SDTC and its current board, stating the obvious that you're here to restore trust within the system, that you are the overseer and you're going to ensure the prudent use of taxpayer money, why on earth would you associate yourself with that law firm when we have dozens of other leading national firms across this country? Why would you associate yourself with that? And you said quite assuredly that he is not part of giving us any legal advice. Well, how do you know that? Clearly, Mr. Vandenberg is not part of your meetings, but how do you know he is not continuing to provide advice to other associates or other partners who in turn give you advice? An obvious answer to that would be to cease all operations with Osler's. So why aren't you doing that?
Mr. Chair, SDTC has no longer has any relationship with the lawyer who provided that advice, and we have engaged an independent conflict of interest and ethics advisor for the board and for the organization from a different law firm.
Is Osler giving you legal advice, yes or no?
We engage a number of law firms.
Answer the question. Ms. Morgan,
us,
answer the question. Is Osler giving you legal advice, yes or no?
Mr. Chair, depending on the nature of the legal advice, SDTC engages a number of law firms, including Osler, on certain issues.
So Osler is giving you legal advice on certain issues. Now, you're not part of any of the operations at Osler, so you cannot say definitively that Mr. Vandenberg is not part of that process. I think out of abundance of caution, you should be ceasing operations with Osler's. But I'll leave it at that and I'll move on. You talked about taking appropriate action if you discover fraudulent or wrongdoing. We clearly have evidence of Ms. Verscheren enriching herself in decision-making that resulted in a finding of breaching the Conflict of Interest Act. I also heard you say that you will take steps to recover money. That decision by the Ethics Commissioner was made several months ago. You've been on the new board since June the 4th. Why haven't you taken any action?
Mr. Chair, in the past 4 months, the board has focused on taking...
Not my question, Ms.
well-
Morgan. Why have you not taken action on behalf of the Canadian taxpayer to recover the ill-gotten gains of Ms. Verschuren? Why have you not started that process? I don't care about your other priorities. I know that's understandable, okay? But you also have a mandate to recover funds. If that mandate didn't come from the minister himself, I'm listening to your responses. That mandate is part of the new governance system. Why have you not taken steps to recover money for the taxpayer?
Mr. Chair, it has taken a few months for the board to get up and running and start to put in place the processes to deliver on its mandate.
Okay, are you getting legal
including-
advice, ma'am? Are you getting legal advice from a law firm as to how that process should take place to recover funds, yes or no?
We have established a clear process. We have engaged advice. We have engaged independent reviewers.
Instead of
and
speaking
that
in generalities,
process has-
Ms. Morgan,
that process has
Ms.
begun.
Morgan, it's my time. Instead of speaking in generalities, please let's start a refreshing approach and answer a direct question. Direct question is this: are you getting legal advice as to what process should be followed to recover money? Yes or no? And if you say yes, which law firm is giving you that advice?
Mr. Chair, we have indicated to the committee that if we find evidence of fraud or wrongdoing, the board will take action.
Again,
Of
Chair,
course,
she refuses to answer the
Mr.
question.
Chair.
Okay, one second. Yes, Monsieur, point of order.
Just, I would appreciate if time could be given to Ms. Morgan to complete her answer.
Happy to if she actually answered the question.
Sur cet appel au règlement.
Mr. Brock, just 1 second. Oui, Madame, c'est
Yes,
Pour cet appel au règlement, je trouve vraiment décevant que
I think it's very disturbing to see that this witness is not answering any questions that require a yes or a no and is just playing a tape that I'm sure government officials have given her to play. It's important. We have questions. She should answer them as specifically as possible, respecting the time as well as the work that we're carrying out here. Thank you.
very much. Oui, Monsieur Drouin, oui. Appel au règlement encore?
Another point of order. Look, I would just like to ensure that we respect our witnesses. If we don't hear the answers, it can be a little frustrating, but, we do have to hold back as parliamentarians. We need to respect the witnesses, and with due respect for my colleagues as well. I do understand the frustration and feel it, but, he's asking a question, then he would like an answer, even, we don't get the answer. That's not my fault.
No, mais, all right. So I think so you can, Ms. Morgan, you can see the position I'm in. There is some frustration where there are specific questions, but the responses are general in nature. Is this something you'd like to answer or come back to us on with a specific question to Mr. Brock about? Is there, Mr. Brock? Do you want to very specific, short? I don't want any preamble.
Yes, there's no preamble.
Yes.
Are you receiving legal advice about the process regarding recovery? If the answer is yes, which firm is giving you advice?
Thank
very,
you.
Very
is this something
general.
you could either answer or come back to us with an answer
Yes,
on, please?
yes, Mr. Chair, I'd be pleased to answer. Of course, we are receiving legal advice with respect to all of our next steps, including recoveries, and I would be pleased to get back to you with the name of the law firm. I just can't recall at the moment.
Thank you. We appreciate that, and we look for that answer. Thank you.
Thank you, Mr. Chair. I know MP Erskine Smith is new to this file. He's had a whole 3 meetings on it where most of us have been working on it for a year. So I'll just bring a little up to speed on this. First of all, the Ethics Commissioner report comes from a letter a year ago from Conservatives asking to look into one person of the 9 that the Auditor General in the spring found out had conflicts of interest. The Ethics Commissioner reported that 2 is actually 24 conflicts of interest by that single individual. And there are 186 conflicts of interest, or 82% of the transactions, MP Erskine Smith, representing almost $400 million. Apparently, that's something you're dismissing, but it's a clear issue, to the point that the RCMP announced last week they're doing a criminal investigation, just for the record. I'd like to go back to the issue, if I could, Ms. Morgan. You've said if the companies have been found to do something criminal, I suspect you're not going to find the companies did anything criminal. The issue is the directors. Are you and is the acting board doing an investigation into the culture of conflict of interest that created 82% of the transactions being conflicted? Because that's the issue. The issue isn't that some of these companies may have been a reasonable company. It's just that they got preferred access to the funding because of that. And I'll share with you an example. The Visharan Center, the chair sought $6.8 million for her own Visharan Center at Cape Breton University. It did get rejected eventually after being fast-tracked by the VP of Investments at SDTC, fast-tracked that application. That person is now the acting president, by the way, of SDTC. He fast-tracked it. But when it got rejected in the Investment Committee for Conflict of Interest, that same person wrote to staff and said, we will help find funding for the Visharan Center for other parts of government. And then the Visharan Center then went on obviously the employees' work, to get $10 million from ISED and ACOA to help the Visharan Center. So the issue is how board members approved in their little cabal each other's projects, as they declared at the beginning of each board meeting, you know, Larry's got a conflict of this, Rick's got a conflict of that, and these are all the conflict. Now, Larry will leave when his one conflict happens, but we'll then approve it, and then I'll leave when my conflict is up. That's how it works when 82% of the transactions are conflicted. They must have had trouble getting quorum because they were so conflicted. So my question is, are you, as a acting board member, brought in by this minister, Minister Champagne, who said he was going to clean the place up, not engaging anyone to examine, since you've already said the Auditor General's not in again, to examine that culture of conflict of interest in the board that led to these $330 million being given to companies these people had an interest in?
Mr. Chair, the current board does not have any conflicts of interest with sustainable.
This is the problem why we're having these issues with your answers. I didn't ask about the current board. I asked about the past board. How can you do an analysis of whether or not a company is eligible in the restart of this if you haven't done an investigation into the governance conflicts of interest in this organization?
Mr. Chair, in terms of the organization, the Auditor General made a number of recommendations about exactly the issue that the member is referring to, which is the culture and the processes around conflict of interest. And those elements of the Auditor General's report, which were aimed at strengthening reporting and strengthening disclosure, those elements of the Auditor General's report have been implemented.
I'm not talking, I'm sorry, you're not listening to my question. My question is about the restart of funding to these organizations, many of whom, 82%, got preferential treatment. How can you do a legitimate analysis of whether or not their funding should be restarted if the new board is not examining the fact that they got sped up in the line and fast-tracked for funding? It's in emails. They got fast-tracked for funding over other companies. How can you restart that? That's the essence of the problem here. And the new board isn't doing any investigation into that?
Mr. Chair, as we consider our process to restart funding, we will address issues of both eligibility and conflict of interest for previously approved projects.
Thank you very much.
Thank you, Mr. Chair. Ms. Morgan, you have repeatedly said that where there is evidence of fraud or wrongdoing on the part of recipients, that will be considered for the purposes of eligibility. You emphasized time and again the word recipient. Are you considering conflicts of interest on the part of the former corrupt board members in assessing eligibility for projects? Yes or no?
Mr. Chair, the process that we've developed to look at projects in terms of funding restart, which is primarily what we're talking about, will
Ms.
address
Morgan,
both
my time
issues
is
of
limited, and I asked you a
eligibility
very
and
specific
conflict of
question,
interest.
but you haven't answered. And it's an hour and a half into the hearing. You've been asked this question or something in these terms, but you haven't actually given a direct answer.
Mr. Crew, just a reminder. While I appreciate Ms. Morgan is here to answer questions, Ms. Morgan, I will remind you that the time is the members, and I know there's always back and forth when they insist on ending your answer for whatever reason. If you could just yield to them, please. And I appreciate you've been doing that generally. Time is limited, and we are coming to the end. So, Mr. Cooper, you have 4 minutes. You can restate the question, but I think it was heard. Do you want to?
Well,
time is yours. 4 minutes.
Yes or no? Are conflicts of interest on the part of the former corrupt board being considered, being assessed for the purpose of eligibility of those very projects that were approved and went out the door involving conflicts of interest of those board members? Yes or no?
As we look at the process to restart funding, we will address issues of eligibility and conflict of interest for previously approved projects.
So the answer to that is yes or no?
We will look at both eligibility and conflict of interest for previously approved process as we look at
You were very
restart of
specific in
program
using
funding.
the word recipient before. Now I'm asking you whether you are also considering conflicts involving board members. You have refused to answer yes or no on that very specific question. So I'll put it to you again, yes or no.
Mr. Chair, as we look at different issues, different considerations come into play, and vis-a-vis
Yes
recoveries.
or no?
Point of order,
of order,
please.
Chair.
Point of order.
Yes, Ms. Yep.
Should let the witness answer and not badger her. Give her the time to, be able to answer in fullness, please.
Thank you, Ms. Yip. Well, I have another point of order, Ms. Khalid, or Ms. Yip. Yes, all right. So, Mr. Cooper, you have the floor for 3 minutes. Look, I'll just say this to all members on both sides. I appreciate that direct answers are expected. Mr. Cooper is trying to narrow their response. He's entitled to do that. And Mr. Cooper, I turn the floor back to you, please, for 3 minutes.
I'm awaiting an answer to a yes or no question. She's wasting my time. Yes or no?
Mr. Chair, these are complex and nuanced issues, and they need to be looked at on a case-by-case basis under the process that we've established.
So you can't give a yes or no answer as to whether that is specifically being considered. So I'll take it as a no. So which is astounding. And so what it means is that projects that got ahead of the queue because of corrupt board members will continue to reap the benefits of the corruption at
Point of order,
SDTC
Mr. Chair.
that led to the
Point of order,
funds
yes.
and a damning Auditor General's
Yes,
report.
Mr. Durian.
I recognize that it's the honourable member's time, but he's putting words into the witness's mouth that has not been said publicly.
That is what I take from her testimony.
So I didn't catch the putting words. I think Mr. Cooper is summarizing how he sees it. Mr. Cooper, you have the floor for 2:20.
So in essence, it's not a priority to clean up corruption. It's not a priority to clean up the conflicts. It's in fact, what is a priority is the status quo, to get money out the door as quickly as possible. It's really, really outrageous. Now, you said that you are in charge of, or part of your responsibility on the interim board is to oversee transparency with respect to the transfer to the NRC. The SDTC every quarter published all funding decisions, project by project. Will that transparency continue when SDTC projects are transferred to the NRC? Yes or no?
Mr. Chair, I can't speak to that issue. We're in the process of discussion with the NRC.
Ms. Morgan, you said that your role is to oversee the transfer to the NRC. That is your primary focus as a board member, one of the 3 board members. You said transparency is a priority. I cited an example where there actually was a level of transparency at SDTC, and I'm asking you, will that continue? And if you can't answer that, are you at least taking steps to see that it will continue?
Mr. Chair, we've got a process in place where we're working through all of these issues with the NRC.
I ask you a simple question, and you dodge, once again, talking in generalities about process. Answer the question. I asked you very specifically about quarterly reports from SDTC.
Point of order, Mr. Chair.
Yes, Ms. Khalid.
I don't think we're in the business of embarrassing or harassing witnesses that come before this committee.
Look, Ms. Khalid, I appreciate this is frustrating, and ththese are good questions. And we're a parliamentary committee where which the witness can refute. Mr. Cooper's being very specific with respect to his questions, and he is entitled to pose them. I would hope we would get an answer. But when he doesn't get an answer, he is entitled to drill down further. Mr. Cooper, you have the floor.
Point of order, actually.
Yes, Mr.
When you say answer the question, you're not addressing that through the chair. I think that's what my colleague, Ms. Khalid,
all right,
is trying
Mr.
to
Cooper,
say.
then if you could send your questions through the appreciate
Mr.
it.
Chair, can the witness answer the question?
Chair, the NRC is an independent organization, and I am sure that they will be very transparent. But I can't answer the specific question about whether they will follow exactly the same transparency procedures as SDTC.
Again, it's astounding, but you can't assure that there would be at least an equivalent level of transparency, but there in fact might be less transparency, which would completely undermine one of the purported objectives of moving SDTC over to the NRC, that there would be less transparency, not more transparency. I think that what is going on, Mr. Chair, is that the minister is working to ensure that there will not be public scrutiny, that there won't be parliamentary scrutiny in the future of the kind of corruption that has been identified in SDTC.
Thank
it's
you.
about burying the corruption going forward.
Thank you, Mr. Cooper. Ms. Khalid, the floor.
So I want to build again on some of the questions and your responses from previous members, and I think I want to focus in on the corruption associated with the Green Slush Fund, and surprisingly, and actually refreshing, I should use the appropriate phrase, it was refreshing to hear from my colleague, Liberal MP Ikra Khalid, my apologies, actually refer to this as corruption, because that's exactly what it is. And I'm sure, Ms. Morgan, given your level of experience with government, you're certainly familiar with the sponsorship scandal that brought down the Chrétien and Martin governments. You're familiar with that?
Yes, Mr. Chair.
Yes. And it's no small wonder, given the gravity of what we have with the Green Slush Fund corruption scandal, that an associate deputy minister was heard on a secret tape referring to exactly this. This is a sponsorship-style level of corruption within the government, the likes that he has not seen since the sponsorship scandal. So, on the issue then of corruption, it's no small wonder that the opposition parties, collectively all the opposition parties, voted in favor of an order for more transparency. And what that entailed was essentially ordering documentation from the government, documentation from the Auditor General, documentation from the SDTC to shed more light. The Prime Minister, Justin Trudeau, essentially said that sunlight was the best way to promote transparency and accountability. He ran on that in 2015. The order of the House was made June the 10th, 2024. On June the 11th, the clerk of the court sent letters to the clerk of the Privy Council, the CEO of SDTC, and the Auditor General of Canada to inform them of the order. It was to be received, the documents to be received by July the 10th, 2024. And no small surprise, given the level of corruption and secrecy behind this, that a great number of government departments and subsidiaries essentially redacted pages, hundreds of pages of documents pursuant to the order, which is the opposite of transparency and accountability. And of note, I note the Canada Revenue Agency, heavily redacted, the Innovation, Science and Economic Development, heavily redacted, National Research Council, heavily redacted, Justice Canada, and the Privy Council Office. Now, I want to confirm from your perspective the documentation that SDTC provided pursuant to this order was completely unredacted. Is that accurate? Is that correct?
Mr. Chair, we have provided all of the documents requested by Parliament. A very small number were redacted based on solicitor-client privilege alone.
Redacted on the basis of identity and addresses and personal information, or some other reason that you can't get into?
Mr. Chair, the only documents that were redacted by SDTC were documents that included solicitor-client privilege, which is essentially legal advice. We provided 10,000 documents. I believe around 300 of them included some redaction for
300
legal
pages.
advice. Yeah,
Okay.
legal advice.
Okay.
Yeah.
And were you part of that process of gathering up the documents, reviewing it, consulting with lawyers on the basis of what redactions, if any, would be made? Was that a decision made by you and the board?
The board directed staff and council to fully comply with the order.
Okay. And did you or any other member of the board actually review the documents, the some 10,000 pages of documents, prior to its release to the government?
Mr. Chair, those documents were reviewed by staff and council.
Okay.
Under the direction of the board to fully comply with the order of Parliament.
Okay, and given your mandate, your new mandate in terms of rooting out fraudulent and wrongdoing and taking the appropriate action, my spidey sense on what's transparency right now, in the House we have a privilege motion that has been ongoing for a number of days and will continue for a number of days, because it was the government itself and every member of government in the backbench who refused to vote in favor of the disclosure requests and are now opposed to the release of these documents. They're claiming for charter-protected reasons, which is just completely nonsense.
Your question, Mr. Brock, or wrap it up.
Yes,
please.
the question is, do you think it's an appropriate use of our time to demand accountability? Do you think Canadians deserve accountability and full access to all the documents to assist you ultimately in the process of ensuring fraud and wrongdoing is rooted out and that appropriate recovery action takes place? Yes or no?
Mr. Chair, my role is as a member of the board of SDTC, and we have complied with the order of Parliament for the production of papers.
Thank you very much. Turning on to Ms. Yip. We have Mr. Perkins for 5 minutes, please.
Thank you, Mr. Chair. I think I'll start off this round by tabling a motion and then speaking to it, if I could, Mr. Chair. And I think the clerk has the motion on.
Are you moving it or are you tabling it?
Moving it.
Moving it. Okay,
moving
thank
it.
you very much.
And if the clerk could circulate it to members.
We'll wait until you've read it out first
Okay.
to make sure it aligns with anything the clerk may have received.
I'm moving this motion that in relation to the committee's ongoing study of Sustainable Development Technology Canada, SDTC, and given that one, former SDTC board member Andre Lise Matot received SDTC funding for cycle capital investments while she was on the board of SDTC, Despite her being both the founder and beneficial owner of the venture capital firm, and given two, Minister Stephen Guilbeault previously served as strategic advisor for Cycle Capital for a decade prior to running for office, and was awarded shares as part of his compensation at Cycle Capital that he continues to hold. That the committee therefore invite Minister Guilbeault to appear to speak to his past affiliation with the venture capital firm and whether he's been involved in any discussions related to SDTC since joining Cabinet. Now, for those of you who are new to this issue that are on the committee,
Just 1 second, Mr. Perkins. So I'm going to the clerk's going to distribute it. I'm going to allow Mr. Perkins to speak for a few minutes. Then I'm just going to suspend for a couple minutes after that. Ms. Morgan, in the meantime, if you just want to hold fast, but if you're welcome, if you want to stretch your legs, freshen up, or anything like that, just don't go too far. Sometimes these things resolve themselves quickly, and there is one round. There's, I suppose, 10 minutes left. Sometimes they don't, in which case I might very well excuse you. But for now, please feel free to get up, stretch your legs. Just don't go more than 5-10 minutes away. Thank you. Mr. Perkins, you have the floor.
Thank you, Mr. Chair. The Auditor General identified a number of board members who had conflicts of interest. The one who had by far the most in the Auditor General's list was André-Lise Matot. Her firm, which she founded in 2009, called Cycle Capital, which is a firm that invests in clean technology or green technology based in Quebec, has had considerable business. So the Green Slush Fund is a little over $1 billion since its inception, and around, including those identified by the Auditor General and other ones that André-Lise Matot identifies on her own website that she's invested in. The total so far is, are you waiting for it? $250 million of Green Slush Fund money, a quarter of Green Slush Fund money, has gone into organizations, businesses that Cycle Capital has an investment interest in. Now, on the wonderful website that was in the news on the weekend called LinkedIn, you can find out wonderful and incredible information. And current Liberal Radical Environment Minister Guilbeault proudly lists that he was the strategic counsel for Cycle Capital for a decade before he was elected in 2019. And guess what he did in that role? He was the in-house paid lobbyist. And during his time as a paid lobbyist for Cycle Capital received $172 million of the $250 million. That came out of the Green Slush Fund. And in the year and a half before Minister Guilbeault was elected in 2019, he lobbied PMO, and I said 25 times, according to the lobbyist register, on behalf of Cycle Capital for SDTC funds. Very successful lobbyist, obviously, and as part of Minister Guilbeault's reward, Minister Guilbeault got shares compensation in Cycle Capital. Those shares are not held in a blind trust. They are publicly available to see on his conflict of interest disclosure through the Ethics Commissioner's office. He still owns those shares. Since he joined Cabinet, Cycle Capital received $750 million of additional money in the dying days of Minister Navdeep Bain's time as the Minister of Industry. Minister Navdeep Bain, you'll recall, is now selling the largest and most expensive cell phones in the world at Rogers now as his reward for bringing down Rogers' cell phone rates. They rewarded him with a job to promote the most expensive cell phone company in the world. So he gave them $750 million while Minister Guilbeault was still in Cabinet. Then, for 40 months or so, while Minister Champagne was the minister, and had a senior assistant deputy minister in every investment committee and board meeting where 82% of the time they were voting conflicts of interest, including conflict of interest, declared conflicts of interest into companies that Andre Lise-Mateau owned through Cycle Capital, which Minister Guilbeault has shares in to this day. That happened. So the line not only extends from the Prime Minister's office, who handpicked appointed the chair over her conflicts, even though they were warned about it. PCO has said that that's where it came from. And not only has the Prime Minister's office tried to thwart the House of Commons by asking departments to redact their documents from the disclosure the House of Commons asked for SDTC. We have an actual Minister of the Crown who happens to be the Minister of the Environment, which might have some interest in SDTC and its performance, who actually is financially gaining. And by that, I mean Cycle Capital, since Andre Lise-Mateau was put on the board in 2016, tripled in value from $200 to $600 million. Pretty good return for all this. And as we know, because we've had lots of testimony on it, that when a company received a grant from SDTC, that was like a grant, a stamp of approval from the Government of Canada, which allowed those companies to then go out and arrange for other funding, which they may have had difficulty getting. Not just funding from other parts of the government, but just general raising capital. So I think Minister Guilbeault needs to attend our study. He was not on our original list, but the evidence has come up as a result of examination of his public disclosure. And I believe this committee, he needs to be accountable to this committee and testify as part of our ongoing examination. Thank you, Mr. Chair.
Okay, thank you. As I said, I'm going to suspend just for